Look, disability carriers like Aetna will go to any length to deny a disability claim that exposes them to paying benefits for the life of the disability policy, even in the case of a policyholder who has a traumatic brain injury and spinal cord compression. It isn't like the policyholder is going to be miraculously cured and be able to return to work. Let's learn about the many denial tools in the claims denial or termination arsenal and how one court said, no way. Disability carriers like Aetna have many denial tools in their claim denial or termination arsenal. What are they? I'm going to go through a laundry list of them. Paper reviews by liar-for-hire physicians, not so independent medical evaluations, surveillance, a transferable skills and labor market analysis by a liar-for-hire vocational evaluator. So how does a carrier like Aetna use these claims denials tools to terminate benefits? Let's talk about the case of Cohen versus Aetna Life. I think it's a prime example of the lengths that carriers like Aetna will go to terminate benefits to even the most disabled policyholders. Cohen was driving a go-kart during an employer-sponsored event. He collided into a wall, suffering a traumatic brain injury and spinal cord compression. Aetna willingly paid Cohen 24 months of his own occupation long-term disability benefits, but then used every denial tool when the definition of disability changed. They didn't want to pay any occupation benefits for the life of the policy. So they terminated benefits based on a paper review of the medical records, surveillance, and a vocational evaluation. Cohen obviously appealed. Aetna reinstated his benefits because they couldn't document that he could earn at least 80% of his pre-disability earnings given his part-time work restrictions. But that wasn't enough. Aetna went at it again. More IMEs, more surveillance. They couldn't get what they wanted. They even had 2 more paper reviews and more surveillance. They finally thought they had enough to justify another claims denial, and they cut him off again. Cohen sued. The judge, using a de novo standard of review, said not so fast. The judge said that surveillance didn't rebut the medical evidence in the file. It only showed that he could do routine acts of daily life. More importantly, the judge noted that from 2008 through 2018, Aetna's own doctors found he could only work on a part-time basis. Aetna's vocational evaluator couldn't identify any reasonable occupation that would pay him more than 80% of his pre-disability earnings. The judge, who was able to substitute their own judgment for that of the carrier, ordered the benefits to be reinstated and granted attorney's fees and costs. Just a small price for the harm they caused Mr. Cohen. And of course, they had to pay all the back benefits. So what should you do if you're the victim of a denial and the carrier is playing games with you? Don't let the carrier rob you of your financial peace of mind by creating bogus reasons to justify an unjustifiable claims denial. You're only going to have 180 days in which to file an appeal and challenge that wrongful denial. What are you waiting for? Call me today at 727-894-3188 for a complimentary consultation.